In this video, I'll explain why Miami is becoming the lawsuit capital of Latin America. And by the end of this video, you will learn how Miami's transformed itself into the premier destination for international business disputes, what makes it different from traditional legal hubs, and why this matters more for anyone doing business in the Americas. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. Look, I've witnessed this transformation firsthand over my career, and today I'm pulling back the curtain on one of the most significant shifts in international law. Think about this for a minute. Right now, a billion-dollar dispute between a Brazilian company and a Mexican investor is being resolved just blocks from Miami Beach. A Colombian energy firm is arbitrating against a foreign partner in a downtown Miami office tower. And a major construction dispute over the Panama Canal expansion was just settled right here in this city. All right, let's start with a surprising fact. 20 years ago, if you had a major business dispute involving Latin American parties, you'd fly to London, Paris, or New York. Nobody was flying to Miami. But something remarkable happened. Today, between 100 and 200 international arbitration hearings take place in Miami every single year. The International Center for Dispute Resolution calls Miami the preferred venue for Latin American international arbitrations. So what's changed? Well, geography played the first card. Miami sits at the crossroads of the Americas. You can fly directly from Miami to nearly every major Latin American capital in under 5 hours. Compare that to flying parties from Buenos Aires to London. That's a 14-hour journey. When you're coordinating witnesses, experts, and legal teams across multiple countries, location really matters. It matters a lot. But proximity alone doesn't make you a legal capital. There's much more to this story. In the early 2000s, Florida made a bold move. The state passed legislation that fundamentally changed the game. In 2005, Florida amended its legal practice rules to allow foreign attorneys to represent clients in international arbitration hearings. This was groundbreaking. Before this, foreign lawyers faced significant restrictions. They operated in a legal gray area. The single change sent a clear signal. Florida was open for international business. Then came the bigger play. In 2010, Florida enacted the Florida International Commercial Arbitration Act. The law was based on the UNCITRAL model law, which is the gold standard for international arbitration. Only 6 U.S. states had adopted this framework at the time. Florida was positioning itself as arbitration friendly. The message was unmistakable. But here's where it gets really interesting. In December 2013, Miami created something unprecedented, the Miami International Commercial Arbitration Court, known as MICAC. This is a specialized court dedicated exclusively to international arbitration matters. Now let that sink in. An entire court focused only on these cases. Only 3 such courts exist in the entire United States. Now, MICAC does something brilliant. When a case qualifies as an international arbitration matter, it gets pulled from the crowded general dockets. The case gets assigned to judges who have specialized training in international commercial arbitration. These judges understand the nuances. They know the New York Convention. They're familiar with cross-border discovery issues. They can handle cases efficiently, and efficiency matters. Remember that Panama Canal expansion dispute I mentioned? Well, MICAC held an expedited hearing less than 3 months after that case was filed. The judge rendered his decision just 1 week later. Compare that to waiting months or even years in a general civil docket. Speed and expertise create value. Now let's talk about something crucial that many people overlook. The 11th Circuit of Appeals, which covers Florida, has developed some of the most pro-arbitration jurisprudence in the entire nation. The court has consistently held that grounds for challenging arbitration awards are limited strictly to those in the New York Convention. Other circuits have added extra grounds like manifest disregard of the law. Not the 11th Circuit. This predictability is invaluable. Now, if you're enjoying this video and haven't subscribed yet, do me a favor and hit that subscribe button. This channel is dedicated to helping business owners navigate complex international legal issues. All right, let's continue. Now, the infrastructure matters too. Miami has developed an entire ecosystem around international arbitration. The International Chamber of Commerce holds its annual Miami conference here, now in its 23rd year. And universities contribute to research and academic journals. The Miami International Arbitration Society, founded in 2008, promotes the city globally, and professional associations actively support the arbitration community here in Miami. And here's something you might not expect. Miami has a massive pool of bilingual and multilingual legal professionals. Spanish and Portuguese fluency is common, not exceptional. When a Venezuelan company disputes with a Brazilian partner, everyone in the room can switch languages seamlessly. Cultural understandings flows naturally. This removes barriers that exist in traditional arbitration centers. Now let me share some numbers that illustrate this scale. Last year, nearly 1,000 new arbitration cases worldwide were filed with the International Chamber of Commerce. The number of Latin American parties in the ICC arbitration cases rose 15%. Brazil now ranks third globally for ICC arbitration users. This growth isn't slowing down, it's actually accelerating. The types of cases tell their own story. Mergers and acquisition disputes are increasing. Companies are dealing with contract provisions around economic uncertainty, and foreign exchange volatility creates additional conflicts. Put and call options trigger disagreements. Energy disputes, construction claims, intellectual property battles, and shareholder conflicts all flow through Miami's courts and arbitration centers. Recent years brought another wave. The Trump administration lifted the suspension of certain Cuba-related claims under the Helms-Burton Act in 2019. This unleashed litigation in the Southern District of Florida. Claims worth billions of dollars were filed. Companies faced allegations of trafficking and confiscated properties. These complex cases require sophisticated legal expertise. And Miami had it. The economic impact extends beyond legal fees. International arbitrators stay in Miami hotels. They eat at local restaurants. Court reporters, translators, and expert witnesses all benefit. The entire hospitality and professional services sector gains from this. And this creates a virtuous cycle. More cases attract more expertise, and more expertise attracts more cases. Traditional hubs are taking notice. London, Paris, Geneva, and New York still handle massive volumes, but for disputes involving Latin American parties, Miami has carved out dominance. The convenience factor is undeniable. The cost savings are real, and the specialized expertise is proven. Companies doing business across Latin America now routinely include Miami arbitration clauses in their contracts. They specify Miami as the seat of arbitration. They designate Florida law. This happens before any dispute exists. The confidence in Miami's system drives these decisions. And Florida's federal courts also play a role beyond MICAC. Judges in the Southern District of Florida regularly handle sophisticated international litigation. They understand jurisdictional complexities. They navigate choice of law issues, and they enforce foreign judgments and arbitral awards. The entire judicial system has adopted. Looking forward, the trend is clear. Latin American economies continue developing. Cross-border investment keeps growing, and regional trade expands. All of this generates disputes, and those disputes increasingly find resolution right here in Miami. The transformation is complete. Miami went from overlooked to indispensable, from afterthought to first choice, from regional player to international hub. This didn't happen by accident. It resulted from strategic legislation, institutional development, and community commitment. So there you have it. Miami's rise as the lawsuit capital of Latin America came from a perfect combination of geography, legislation, specialized infrastructure, expert judges, and cultural alignment. The city seized an opportunity that others missed. If you found this video valuable, please hit that like button and make sure you subscribe to this channel. I regularly break down complex legal topics that affect international business owners. Knowledge is power in the global marketplace. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.